Good morning and welcome to today's webinar, Legal Fundamentals for Startups. I'm Cassie Powelson, Head of Content at Atrium and your moderator for today's webinar. Before we get started, I want to go through some before we get to webinar logistics, I want to introduce our speakers and tell you a little bit about Atrium. Atrium is a full-service corporate law firm that uses modern technology to deliver legal services that are fast, transparent, and price predictable. Founded by Justin Kahn and backed by Andreessen Horowitz, YC, General Catalyst, and more, we are trusted by over 300 of the top startups and hyper-growth companies in and outside of Silicon Valley. Now on to the logistics. This webinar will roughly be 45 minutes of content and Q&A. You can submit questions at any point during the webinar by clicking on the chat icon that's at the bottom of your screen and then submitting your question in the right-hand side panel. We'll address all questions at the end of the presentation. Today, I'm excited to introduce to you our two speakers, two Atrium attorneys, Natasha Allen and Jared Verzello. Natasha is an experienced startup and venture capital and M&A attorney on the Atrium Counsel desk. She acts as an external general counsel role for several clients in a range of industries. Prior to working at Atrium, Natasha was an associate at a top law firm and many corporate and security groups, and in a previous life was a corporate and tax attorney in Canada. Jared primarily acts as outside counsel to venture-backed tech startups. He personally guides companies through general corporate matters such as formation, fundraising, hiring employees, and managing board meetings. He also acts as a guide to Atrium's many specialists to help navigate through the unique issues faced by many hypergrowth companies. Jared, I'll pass it to you.
All right, we have four basic topics that we're going to cover. I want to start off with a clarification, which is these are legal fundamentals for venture-backed startups or companies seeking institutional investors. Much of the advice that you'll hear today is not applicable for small businesses or lifestyle businesses. These are businesses who are seeking to have professional investors invest in their companies and become high growth in the mold of a Silicon Valley startup. So with that being said, our four basic topics are forming a company, your first hires, protecting your intellectual property, and fundraising. Natasha and I will tag team these topics, and I'll jump into the first one, which is forming a company. So our key takeaways here, you're going to want to choose a Delaware C Corp, and you're going to want to ensure that all of your service providers assign the IP over to the company and that they have vesting. So I get the questions often of why do we have to do a Delaware C Corp? I'm a California company, or we're in Nevada, or aren't there better tax advantages for doing other things? And the short answer is you need to be a Delaware C Corp because that is the type of entity that institutional investors want to invest in. And if you are seeking to become a venture-backed company, you're interested in being investable. So let's dive into that a little bit more. Think about this from the perspective of the investors for a second, rather than the perspective of the founders, who may be in Tennessee or California or wherever and may not have really no connection to Delaware whatsoever. Investors are managing a large portfolio of investment companies. They're deploying capital into numerous investments and having to supervise and monitor their investments. If you take an extreme example like a Y Combinator, who invests in about 300 to 400 companies a year and literally has thousands of portfolio companies, the only way to manage that type of volume of company is to ensure that everybody is playing by the same rules, has the same governing playbook. And the governing playbook is dictated by the laws of the state of incorporation for the entity. So the market's coalesced around Delaware. That's why all of your investors want you to use that, because that's what all their other investments are using. And then they know what the rules of the game are for managing their investment there. So that leads to the question of, okay, well, it makes sense that everybody's on the same playbook, but why did we choose Delaware as the playbook, one of the smallest states in the United States? And there's a lot of good reasons for this, but the short answer is if you think about managing a company and the balance of power between the management, which is the board of directors, the founders, the senior executives, and the stockholders of that company, which may include all of those categories, but also includes employees, and eventually when a company becomes public, the broader can be the broader population. When you think about governance as a balance between those competing stakeholders for who controls the company, Delaware really favors a management and board controlled company, which is great for startups because you want ultimate flexibility. You want ultimate flexibility in how to manage your company. Now, moving on to the second point that I want to make in this section, which is you've started your company, you've formed it as a Delaware C Corp. What's the next thing? What's one of the next major things that should be on your mind? You want everybody involved in this startup to be subject to vesting. I mean, there's literally no downside for doing this. Even if it's you and your spouse, or you and your best friend, or you and a former colleague who have worked together for 10 years and know that this relationship is going to go well and that you're not worried about somebody leaving with a huge portion of the equity, this is still critically important because one, startups are stressful, and we do see founder breakups all the time. So one of the things that can really kill your startup when it's very vulnerable is you're a year or two into the business, you're really heads down trying to find your product market fit. Most of the labor is coming from your founders. You have a irresolvable dispute. The founders split up, and now somebody owns 50% of your company who's not here anymore and not working and not contributing. That's really difficult to overcome. And it's really hard to stay motivated as a founder knowing that 50% of the company is with somebody who's no longer involved. It's also true that investors don't want to see that. Investors want to understand that you have skin in the game, and that once they invest their money, their capital is going to have incentives that's aligned with your own personal economics. Something that I think people misunderstand from a market perspective of how investors and other market participants are thinking about the equity is that oftentimes they think that their equity is the reward for their idea, that they had an idea for a company, therefore they should get, it's their company and they should get a big portion of the equity and that it belongs to them. And I think really in the vein of Silicon Valley, which is ideas are cheap and easy and execution is hard and what's rewarded, your equity is something that you earn over time through years of execution. And the amount of equity that you have the opportunity to earn as a founder is an orders of magnitude larger than what even your early employees will receive. And so really the reward for you being the founder is that you're on a path to earn 40, 50, 60% of the company's equity, but still keep in mind that it is yours to earn even as the founder of the company. And that's the role that vesting plays. So I'll pass the mic over to Natasha to take our second point.
Hi, hi, good morning, everyone. Natasha Allen here. I'm going to talk about your first hire. So now that your company is formed, you need individuals to come in and help you develop and move the company forward. So you've probably heard that there are, when you speak to your attorneys, there are a variety of cautions that they put before you. One of them being, how do you characterize your service provider? So your service provider could be either an employee or an independent contractor. And most people wonder, why do we care? Like, why do you care if I characterize this individual as an employee or as an independent contractor? And the main reason are the penalties that are associated with the wrong characterization. So for employees, employers are supposed to withhold taxes, they're supposed to pay Social Security, Medicare taxes, unemployment. And for failure to do that, there are some very stringent penalties. For California specifically, they can impose civil fines of $5,000 to $25,000 per violation. You also have violations for the federal government for imposing of tax penalties, unpaid Social Security, et cetera, et cetera. In the really extreme cases, if the IRS thinks that your mischaracterization was blatant, They can impose criminal sanctions of jail time for up to 1 year and fines of up to $500,000. So that's why your attorney usually harps on, are you characterizing your service providers correctly? So now the next question is, how do I make the distinction? In California, they've established what is called an ABC test, which makes it a little more difficult now to make the distinction, but not impossible. So the things that are looked at are, as usual, is the worker free to control and direct the way that they do their job? And so that has to be true freedom. Even if there is a hint that even though you have the ability to direct an employee or a contractor, but you don't exercise that right, that still does not fall within them being an independent contractor. They have to be given the opportunity to be given a task and foresee that task however they see fit, to the extent that they get to the end result that you'd agreed on. The worker has to perform work that's outside of the usual course of the company's business. Now, this one is a little difficult. So if you are hiring someone to do things such as HR, that's outside of, that's within what you're doing. So if you're an HR consultant and you're hiring someone to do HR work, then you're not actually hiring a consultant, you're just hiring somebody who could be employed in your company and under what would maybe be considered the guise of an independent contractor. The third is, does this individual actually engage in this activity outside of just us helping you as an independent contractor? So usually that translates into whether they have other customers or clients in which they do the same type of business for or activities for, which then again indicates that this is not only something solely for your company, which could be some under the guise of an employee acting as an independent contractor. The other thing is that the independent contractor, if they are mischaracterized, could also seek, the IRS could also seek that they return some business expenses that they would have deducted during the period of time that they were mischaracterized as an independent contractor. So it's kind of cuts both ways. Both the employer can be impacted as well as the independent contractor can be impacted. Another distinction that some people have a little bit of difficulty distinguishing between are advisors versus independent contractors. So advisors should be considered as those individuals that provide mentorship for a company, provide more guidance for a company, as opposed to trying to deal with specific tasks. So independent contractors would have a specific project and an end goal in terms of which they're trying to help you achieve, whereas an advisor would be an individual who'd be providing more guidance and helping you to direct you towards how to achieve your goals. And both have different forms of agreements, and your attorney would have all types of, all three of them, an offer letter, as well as independent contractor agreement or advisor agreement. And all of them are slightly different, and so it's very important that you make sure you're giving the right documentation to these service providers. So now that you've decided whether you have an employee versus an independent contractor versus advisor, in the circumstance of an employee, how do you pay for these employees? So if you're like most startup, just starting off the ground companies, cash is light. So you probably won't be giving huge salaries to these beginner or start off employees. But what you can offer is equity. So most clients wonder, okay, if I can offer equity, how much equity do I give? This is very dependent on the type of industry you're in, the market you're in, and who you're trying to hire. Some people say allocate, 10% of your equity for your first 10 hires and disseminate it amongst those first 10 hires as you like. Some people say take as much as 15 to 20% to be allocated amongst the first hires, the key hires. Usually you see executives, so senior executives would get anywhere between, say, 1% to 4%, and that varies. And then junior employees would get anywhere from 0.1% to 0.2%. So there is a lot of flexibility, and it does really depend on the industry you're in and the type of role that you're trying to entice someone to come into. So definitely this is something that you'd want to speak to your attorney about. They would have huge experience in terms of what they're seeing in the market with regards to what type of equity is being offered to different roles in a company. On the topic of equity, so equity, I'm sure you've heard about all the different things that you can fall into when it comes to to equity? Do you offer an NSO versus an ISO? Do you offer stock options or do you offer restricted stock? There are very huge differences between all of these different topics, and most of them are tax driven. You know, we couldn't do justice with trying to go over all of these in a 5-minute presentation. I think that all of these topics in and of themselves are a presentation that maybe we'll do one day. But when you're dealing with granting equity, you want to make sure that you speak to someone at the beginning. Because a lot of things that you do when you're trying to, even if you're trying to grant stock options, the first thing you're supposed to be doing is having a 409A valuation and trying to reverse or undo equity grants if they're improperly perceived or instituted in the beginning is in some cases impossible, and in other cases very expensive and very difficult. So if you're at a point when you're thinking that, you know, I want to grant some options or even restricted stock, we suggest that you talk to your attorney to make sure that you're not tripping up on any of the different potholes or different trip ups that you can get when you're trying to issue grants. Now I'll pass it over to Jared to talk about protecting your intellectual property.
All right, as mentioned at the beginning, the target audience for this presentation is really a venture-backed startup. And so oftentimes that means technology company. And I think it's worth taking a moment here to talk about what a technology company looks like today. Technology companies are not limited, and venture-backed companies are no longer limited to people who make software. It's a much broader category than that. Oftentimes, there's a kind of Silicon Valley or West Coast bias towards those deep tech companies, people with software, heavy engineering, life science type of focuses. But what I see more and more on the East Coast are companies that are really innovating on their business model and have the ability to use modern technology to innovate in legacy industries. So the following is applicable for all of the above, right? And I'll give you a quick anecdote. I was meeting with a client recently who is a packaged goods company and a venture-backed company, okay? So they basically compete with kind of traditional potato chip makers, but they have, you know, kind of a different way that they go about doing this and use a different product. So I was meeting with them and we were talking about intellectual property, and they said, oh, well, we don't have any intellectual property because we make snacks, right? And at the beginning of that meeting, they pulled out a bunch of different bags with different flavors and handed them to me and gave me a sample of them, and I was eating them and they're delicious. And then, you know, halfway through the conversation, they said, we don't have any intellectual property. And I said, well, what about this packaging, right? What about this branding? What about the actual recipe for this? And as we kind of dove into it, they realized, sure, we don't have, you know, an iOS app, but we have intellectual property that's important to us, that is a differentiator and why people choose our product over other people's products. So don't tune out if you don't think you have intellectual property. I promise you, if there's an institutional investor who wants to invest in your company, there's something proprietary there that they find interesting, and you have intellectual property that you want to protect. So for those of us who have worked at kind of large technology companies, we know that a condition of employment at those companies is you kind of have your offer letter, you negotiate your salary. If you're lucky enough to get stock options, then you negotiate that. But you'll always be asked to sign a technology assignment agreement. And they have different, you know, the documents are titled in different ways. Sometimes they're referred to as CIIAs or CS, but it's just confidentiality and invention assignment agreement. But this is table stakes in the industry. And the idea is a big value and a big asset of these companies is that they have this proprietary technology and that they employ people to help promote that and invent that in some cases. But at the end of the day, it is everybody's understanding that the technology belongs to the company, and that is part of the value that they offer. So these agreements are simply private contracts between the employer and the employee, or the employer and the consultant, or the employer and the advisor, those three categories that Natasha just discussed, clarifying what constitutes intellectual property and who owns it. it's very important to have these agreements. One, because they're standard. So people are expecting to have to sign these. So there's no expectation that somebody's going to come and work for you and draw a salary and get stock options and keep all of the rights to their, inventions, whether they're packaging or software code. So please do that. Two, if you don't sign these as private contracts, then it becomes very nebulous about who exactly owns this. And we have to go to default laws on the books of the states in which the person's providing services. And we have to look at court cases, and we have to try to figure out what exactly do we own, when we could simply sign a more or less off-the-shelf agreement and have perfect clarity on it. An extreme example, but something that's happened to me in my practice is received a client who had received a term sheet and was going to raise a Series A financing round. So they kind of felt like they needed to go and find a lawyer who was more familiar with that. So they ended up coming to me, and we did the round for them. And during the course of the due diligence, we found out that they had hired a key employee, an engineer in this case, about a year prior, who had made some significant product development for them, but never signed any of his paperwork, never signed his IP assignment agreement. And during the course of the due diligence, the investor realized, hey, this person didn't sign their IP assignment agreement. We'd like to move forward with the round, but not until we go and get this signed paperwork. So at this point, that particular employee hadn't been with the company for quite a while, and unfortunately had a contentious separation. And he simply refused to sign the paperwork, and it held up the round. In the end, my client had to go back and give this individual significantly more equity in the company, relatively a small amount, but significantly more than that person was owed for his services, because he basically was in a position to hold their fundraising round hostage until that was done. And they determined that it was more efficient to give that person the equity and move forward than put the fundraising on pause and redesign that entire portion of the product that this person had contributed. That was a really poor outcome for something that could have been a really, really simple fix, which is just signing the paperwork at the beginning. So everybody needs to sign this. Everybody needs to sign this. Everybody who works on the company, whether or not they're your best engineer or, somebody who you don't associate with producing intellectual property. Err on the side of having everybody sign these. The second thing, which also touches on my story about the packaged goods company, is doing trademark searches and how do you balance spending precious resources on professional services versus funneling all of your resources into product development and product market fit. And so I get this question a lot, and I think the short answer here is actually pretty simple and intuitive, which is you should, in my opinion, you should not be making major expenditures in branding and marketing without first doing a trademark search. So you're launching a landing page, you're doing some A/B testing, you're hiring a designer to do some mock-ups of different, packaging or website designs. I don't consider those major expenses. Those are things that you need to do in order to just understand that you have some traction and that you're going in the right direction. However, before you do a manufacturing run with that design that you like, or do your product launch and brand with that logo that you love, I think it's worth engaging a professional to do a trademark search and make sure that those marks and brands are free and available for you. Because there's nothing worse than spending 10% of your operating capital on a huge product launch with branding that you absolutely love and a product name that you love. And then 6 weeks later, you get a cease and desist letter from a trademark holder, and you have to scrap it all because you can't afford to, even defend your rights in court against them. So unfortunately, I've seen this happen. It's simply something where an ounce of prevention is worth a pound of cure. It's going to cost you $500 or $600 to do a full-blown trademark search, but that is money well spent. when you're launching your product, because you only get one shot to do that. Okay, to Natasha for our final point on fundraising.
All right, so how do we get money through the door, which is a very important thing for all companies. So there are three things that I'm going to touch on. One is going to be a SAFE, the other a convertible note, and the final is going to be a price round or an equity round. So most of you may have heard of SAFE. SAFEs are the simple agreement for future equity. Essentially, they are not a debt instrument. They're a very unique kind of way of getting money through the door. Typically, they're used by by companies that are just starting out. And as I said, it's a very quick way to get money into the company so that you can start doing what you set out to do, which is develop your product. Safes are usually not very contentious, and there are only usually a few points that are negotiated. And that's why they are so effective in terms of getting money through the door quickly, is that most people are familiar with the SAFE form. And when I say people, I mean investors. So in terms of what they're getting into, all investors are pretty familiar and make the negotiation less contentious. But there are a few things that investors will try to negotiate. One of them being a valuation cap. And what a valuation cap is an amount that sets the value in which a safe holder at a bare minimum could convert their valuation dollars into preferred stock. This just is a way to help those investors that are early investors to make sure that they aren't going to be diluted by some other huge extraneous valuation in the future or lower valuation where they're going to lose out. And it's just a way for them to be incentivized and also rewarded for being early adopters and investors in your company. Another thing that is highly contentious, or not highly, but that's negotiated, is the discount rate, and whether you even have a discount rate. A discount rate just means that upon conversion, when you're moving your safe, and there's an equity round, and typically when a safe will convert into preferred stock is when there's an equity round. The safe holders will get to purchase those preferred stock in the equity round at a discounted rate. So if my preferred stock in an equity round is $1 and your safe holder had a 20% discount, that means that they can buy that same preferred stock for 80 cents. So both of these, again, are to help early investors, to protect them for being early adopters into a company, and so that in the future they don't get diluted and their investment becomes almost null and void. Other than the SAFE, there is what is called a convertible note. So some people may be more familiar with convertible note. A convertible note is an actual debt instrument, meaning that it is debt on your books. It's not an equity investment. Convertible notes are definitely a lot more stricter than safes because they actually do have a maturity date. So either the convertible note has to convert into some type of equity, or the amounts have to be repaid. Convertible notes also have interest that has to be levied yearly or annually. So with the safe, you don't have any maturity date. A safe can be outstanding for as long as you want. The only triggers are if you have an equity financing, an IPO, change of control. Whereas a convertible note will have an end date. Also for convertible notes, which is different from a safe, is that convertible notes have an interest rate that has to be levied, whereas safes have no interest rate. Convertible notes are an interesting option. Some investors may not be familiar with the SAFE instrument, especially if you're not in the Bay Area. I've had some clients with investors in other areas that are very confused about what the SAFE is supposed to achieve. So sometimes they revert to a convertible note, which is something a little more understandable outside of the Silicon Valley. The final, one of the other options in terms of getting money through the door is a price round or an equity round. This is when you would actually have a specific term sheet. You'll have an investor that will want to definitely do some due diligence to make sure that what they are investing in is what they are actually, what is actually out there what is actually in your term sheet in your company that you've established is actually what they're investing in. A price round is a lot more work in terms of just making sure that your documents are in order, because there is a diligence process In addition, there are way more documents that have to be signed, executed, negotiated in the context of an equity round. And also the difference with an equity round is at this point, you usually will have, at the end of an equity round, you will have an investor or multiple investors that will now be on your board. So you have a lot less flexibility with an equity round in terms of being able to run your business as you see fit. Whereas with a SAFE and a convertible note, it's essentially these investors are putting money in and allowing you to run your business as you see fit. Whereas with a price round or an equity round, you have a lot less flexibility, and you will have investors that will want to know kind of how you're running your business and the trajectory of how things are going. So that's usually something that happens a little later stage. In terms of when you raise how much on what, usually SAFEs are probably, if you're raising between 4 to 5 million, you'd use a SAFE. The first maybe SAFE round would be friends and family. Then after that would probably be angel investors. But regardless of which mechanism you use to get money through the door, the easiest and quickest way to get through any of these is just to make sure you're organized. So when I say organized, I mean have a Dropbox that has all of your formation documents, all of your shareholder consents or board consents in one place. This will make your life extremely easy, whether you're going through an equity round or, a pretty high value SAFE round. But just having your documents set in place as they come in, as you sign documents, it will make your life a lot easier. In terms of just figuring out, okay, well, what will I need to know if I were going to go for an equity round and somebody was to do due diligence? You can go online and find due diligence checklists. You can talk to your attorney to find out, okay, what documents would somebody actually be looking at if we were supposed to go for an equity round? And just keep that in mind as you're going through and running your business. In terms of what you should be keeping track of and putting in one stable static place. So pretty much to prioritize, I think if you're early stage, you want to start with a SAFE. It's the easiest and quickest way to get money through the door. Convertible note would be the next in line, especially if you have an investor that's not very familiar with the SAFE and what it's supposed to be doing. And then finally, the price round. Because again, with a price round or an equity round, you're going to be losing control, not all control, but a bit of control in terms of the flexibility of running your business. And final and foremost, just be organized. I think that's kind of the common theme throughout all of this that we've been harping on, is that the more organized you are, the easier it is for you to get money through the door, the easier it is for you to run your business.
Awesome. Great. Well, we're going to jump to Q&A now. So if you guys have questions, please, at the bottom of the screen, there should be a chat button, and then there will be a panel on the right-hand side that'll pop up. So we're just going to go through the questions that have come in so far. So with point number 1 that you were talking around Delaware C Corp. So what if a company is not Delaware C Corp, Jared, and how would you go about changing this, and how long do you expect it to take?
Yeah, this is a great question, extremely relevant, and I deal with this every single week. So you're not a Delaware C Corp, but you're hearing the advice and you recognize the benefits of becoming a Delaware C Corp. I think the first thing that I would think about is, because you're already in this situation, when do I move forward with the conversion? And I'm very conscious of this idea of you have limited resources, so you can't, it's not always the best use of money to spin up lawyers and professional services to do something in a super preemptive way. So in my opinion, once you've already gotten yourself into a company, I'm assuming you assign the intellectual property into that company or have some initial customers or some vendors, there's real operations in this business. So you can't just walk away from it. I would say you should probably leave that as is until you have secured some financing, and either your investor will tell you that you need to change to a Delaware C Corp as a condition precedent to doing the financing, or if you've raised, I would say, $250K or so, maybe $150 to $250K, which is a substantial amount. Now you have some real capital, then you can consider doing it preemptively. But I wouldn't just, if it's 2 co-founders, you're working on the business, you've quit your jobs, you're trying to make it work, I wouldn't spend, $5,000 or $10,000 converting your entity preemptively. make sure that you have product market fit, make sure you're building something that people want, and you go out and when you raise money, the market will tell you when it's time to change. Now, the catch-22 here is the longer you wait, the more difficult the conversion will become and the more expensive the legal fees and accounting fees will become for changing that, right? So if you thought you were going to be a venture-backed business, but started as whatever, a Florida corporation, because you didn't get the advice of starting as a Delaware corporation early on, and you're not raising money, but you're starting to have some cash flow and you're starting to hire employees, that may also be a time to think about this. So once your business goes from kind of initial bootstrapping to the next level, usually for venture-backed companies, that means you've gotten some initial traction that allows you to go out to the marketplace and raise, $250,000. But really, it's when you go from step 1 to step 2 in your business that you need to kind of make this conversion.
Great. Can you define valuation cap?
Sure. So valuation cap. So valuation cap is the amount that your investment can convert. So if you're thinking of, so it's how much is my company worth, right? So you'll see valuation caps from anywhere from like $10 million. So I think that my company would be worth $10,000 after you do an investment. And that's essentially what it is. I don't know if you more at.
No, I think that's right. I think there's a lot of kind of technical legal mechanics around doing the math for stuff, but essentially it's a proxy for saying what the investor thinks the company's worth today.
But as Jared said, there are a lot of different inputs to determine what a valuation cap is.
Okay, great. And how do you go about choosing a lawyer? What are clues to spot a good and bad lawyer?
So I think, first of all, when I think about what are you looking for in a lawyer for a venture-backed company, there's really 2 buckets that I think of. The first is kind of table stakes. It's the technical competency, right? Like, do they know the law? Can they do the drafting? Can they get the job done that I need them to get done? The second bucket, which is not as obvious to many clients, is they can act as a great source of market intelligence for you. So a great venture-backed lawyer is constantly doing fundraising rounds, constantly incorporating companies, and they have a very good sense of what are market terms. For the valuation cap question, right? You get an initial investor who gives you a $4 million valuation cap, and you're a San Francisco company, and you're thinking, that's pretty good. I would sell my company today for $4 million. And you may be able to ask your lawyer who might have done 60 safes that year, right? Just has a lot of exposure to what other companies are doing and what kind of valuation caps are being set. And they might tell you, hey, for a San Francisco company at your stage with your traction, this seems a little low. I would have expected something more like $5 or $6 million. Now, that's just a data point, right? Your lawyer is not a valuation expert. That's ultimately going to be a negotiation between you and your investors, but it's really helpful to have that data point. So when I'm looking for a lawyer, what I'm looking for, because it's very difficult for you to judge their technical competency, what I'm looking for is somebody who actually has a significant number of annual transactions with companies that look like mine. So if I'm doing incorporation, what I want to know is, hey, approximately how many startup companies have you incorporated in the last year or in your career? If you're raising money, I really want to know that my startup lawyer has done minimum 20 financings, right? If you're talking to somebody and they have not done at least 20 financings, I don't think that they have the critical mass of experience to be able to really provide you the market intelligence. And because you're not going to be in a position to gauge their technical competency very well, I think the market intelligence and the exposure is a good proxy for that, because it's hard for them to keep getting more and more and more financing transactions if they're not good at it. Now, you should always ask for referrals, right? You should ask your friends who are entrepreneurs and actually can provide an informed referral, but also think about reaching out to alumni from your school, or if you have the luxury of having investors, asking them for advice. So referrals are great, but once you have that connection or you find an attorney, the way to validate them, I think, is through those transaction numbers and understanding what they're asking, right? How many safe financings have you done? How many equity financings have you done? How many companies have you incorporated? Have any of your clients ever sold? Did you handle the M&A? Those are all really pertinent questions.
I think also that you want an attorney that you actually trust, because they have a very key component in helping you achieve your goals. So you do want to make sure that you're dealing with someone that you actually, once you get on the phone with them and you've had a discussion or a couple discussions, that you actually trust them, because they are as important to help you move your company forward as your lead engineer, right? They're there to help you and guide you and navigate you through the legal hurdles that you'll encounter during your whole company progression. So definitely someone that you feel like you can trust and have a good understanding.
Awesome. Okay, and so let's go to the next question. As a co-founder, that maybe is working somewhere full-time somewhere else, can a co-founder be a contractor, and what different equity things should you consider perhaps if the co-founder is working part-time for you?
So the first thing is, if your co-founder is full-time somewhere else, are they really committed to the company? That would be the first question. Sometimes you're caught in a circumstance where you're full-time, you're going to leave, and then you'll join the venture, which is definitely, I've seen that happen, and that's not a problem. But typically you want your founders to be fully committed, and investors will be looking at that as well. They do not want part-time co-founders. They want full-time people who are committed to the company. If you're in a circumstance where your co-founder is full-time somewhere else, but they're trying to still help get this company off the ground, the main thing I would say is you need to ask that co-founder if they've signed anything in their full-time agreement that would prevent them from being able to have a part-time gig. A lot of tech companies have non-competes in their, or not non-competes, but confidentiality provisions in their offer letters, CIIAs, that could cause for some, havoc for the co-founder if they're trying to work on another business venture while they're still fully employed somewhere else. I think a contractor agreement is a good idea, because you want to make sure that anything that the individual is developing for your particular company will remain with your company, right? So it won't be a circumstance where any IP that's developed or any inventions that are developed will now become maybe part of their prior employer or belong to them personally. But again, I think the main key gating factor would be to figure out what are the limits with that co-founder in terms of their current full-time employment agreement.
Awesome. Okay. And what's the real difference and thing to consider when raising a pre-money versus post-money safe? And then the second question to build off of that are, what are some red flags founders and investors alike should look for in post-money safe provisions?
Yeah, so just as a quick refresher, the SAFE is an instrument that was introduced by Y Combinator back in 2013, 2014. And when it was introduced, there was no such thing as pre-money safe or post-money safe. It was just the SAFE. And it just so happened that it was what we're now calling the pre-money safe. And I'll get into that in a second. In September of 2018, so very recently, Y Combinator released a new SAFE, which they've specifically called the post-money safe. And it is a very similar instrument, but the economics of the instrument work differently. So what are the real differences? The difference is that with the old pre-money safe, you establish the valuation of your company with your investor via the valuation cap, right? But you establish that valuation regardless of how much money you end up fundraising, right? So you say, hey, the company's worth $10 million, and then you go out and you fundraise on that, and you get as much or as little money as you want or you can, right? You may have a $10 million company and decide to raise $1 million. You may want to raise $1 million, but only are able to raise $500,000. And that doesn't affect the valuation of the company because it's all done on a pre-money basis, meaning pre-investment money basis. Now, the new post-money safe actually flips that around, and it says, we're going to value your company on the combination of what we think the company is worth today, plus all of the money that you're raising in this round. So you're out, you're fundraising, and you're saying, hey, we're a $10 million company, we're going to raise $1 million. And so the safe investors say, okay, well, that makes it an $11 million post-money safe. Now, there can be a little bit of fallout if you don't raise the entire round. And so this instrument assumes that you have really gone out, found all of your investors, got all of your commitments, and you really know how much money you're raising. It really treats it more like a fully baked, thought out round as opposed to just kind of running around and fundraising on a one-off basis. The biggest difference, and this goes to the question of kind of what are red flags to look for with the post-money safe, is the post-money safe commits the company to give the investor a determined percentage of the company. And it happens on a mathematical basis because of the post-money function, which I won't get into all the legal mechanics of here, but consider this. You have a $15 million post-money save, and one of your investors invests $1.5 million. Now, that's a large safe investment. What that means is that the company has now committed to issue that investor 10% of the company at the time of their first equity financing. Okay, so the way that this can turn out to be not so great for the company, and by the way, that's great in the sense that everybody knows exactly what deal they're striking. The company knows they're getting $1.5 million, and the investor knows they're getting 10% of the company. And that makes negotiation very quick and simple and makes fundraising easier. With the pre-money safe, right, if you have a $10 million company and you're raising $5 million and one of your investors is putting in $1.5 million, they're not exactly sure how much of the company they're going to end up with because they don't know if you're going to go out and raise the entire $5 million, right? So sometimes that can create a wait and see kind of mentality with investors, which can retard fundraising. With the post-money safe, the benefit is you get this very simple, transparent negotiation, which can often lead to quicker fundraising process. However, the problem is if you have a post-money safe round, that investor, because they've gotten a fixed percentage of equity, they will not take any additional dilution from subsequent investors until you do a priced equity round. So what that means is, if you're like most companies, at least in Silicon Valley today, which is where most of my clients are, most companies are raising a safe round of financing, a small safe round of financing, say $250,000 to $500,000, and then within 9 to 12 months later, maybe 18 months later, they're going to go out and they're going to raise a larger safe financing round, maybe of $1 to $2 million. And then a year or two after that, they'll actually finally do their equity round. So what happens if you're in the position where you've done a post-money safe round as that first initial financing, you've committed to give your investor a fixed percentage of the company at the equity round? What that means is that the other safe round in the middle, which you use to raise another $1 or $2 million, the investor takes no dilution in that round. But because a percentage of the company has been sold, right, those new investors get something for their money. Because a percentage of that company has been sold to those new investors, and because the old investors don't take any dilution from that round, that means the founders and the early team members will take more dilution. They'll shoulder all of the dilution themselves. Now, I'm doing my best to answer this question. It's a little bit of a technical question, and we actually have a post on our Atrium blog that's specific to this question, which goes into more detail with more examples. So anybody who has follow-up questions on this point, please check out the Atrium blog, and you can have a more in-depth response.
Awesome. And we are at time, a little over actually. So thank you for everyone that joined today. We will be emailing out the recording within the next day. And we will keep you posted on the next webinars we have. Thank you so much.